Hello to everyone. I'm Stefano Morici, Erasmus student of Caltech of 2021, and today I'm going to present the Bodil Lindqvist case. It was a judgment of the court, number 101 of 2001, in which the court ruled for the first time on the scope of the Data Protection Directive 9536 and freedom of movement for such data on the Internet. This case represents a milestone and a crucial moment for the development and enforcement of data protection law because it was the first time in which the European Court of Justice, in a preliminary ruling, clarified and established clearly the objective of the Data Protection Directive that later we will see. So, the facts. What happened? Mrs. Lindqvist was involved in preparing people for communion in the parish of Alseda in Sweden. At the end of 1998, she set up internet pages on her personal computer at home to enable parishioners preparing for confirmation to obtain easily the information they were likely to need. Those pages contain information on Mrs. Lindqvist and 18 of her colleagues in the parish, including their first names, and sometimes their full names. Mrs. Lindqvist also described the work done by the church volunteers and their hobbies, family circumstances, and telephone numbers. So what basically happened is that Mrs. Lindqvist, in setting up those internet pages, attached some personal data of the parishioners. Which were the consequences of those acts? So, Mrs. Lindqvist, after that, was fined approximately 450 euros for three main points. The first one was for processing personal data by automatic means without notifying the data inspection, namely the Swedish Supervisory Authority for the Protection of Electronically Transmitted Data. The second point for which Mrs. Lindqvist was fined is for processing sensitive personal data without consent. For example, Mrs. Lindqvist referred and wrote about a foot injury and a part-time work on medical grounds about a parishioner. And that was personal data. Then the third and last point was for writing and transferring data to third countries without authorization. Mrs. Lindqvist, of course, didn't accept this fine and appealed against that decision to the Gotha Hovrätt, namely the Sweden Court of Appeal, which, after this, asked the European Court of Justice, in a preliminary ruling, whether the activities with which Mrs. Lindqvist was charged were contrary to the provision of the Data Protection Directive, which is intended to ensure the same level of protection in all the member states for the rights and freedoms of individuals in that regard. Mrs. Lindqvist's reasons were that she wrongly considered the creation of a personal website a personal activity allowing her to be exempted from the data protection rules. She argued that it was unreasonable to suggest that simply mentioning a name or personal details on a web page was a breach of data protection rules. Okay, so in the preliminary ruling, the court has held that for what concerned the first point, the court confirmed the fine that Mrs. Lindqvist was charged before. So, the court confirmed that the act of referring on an internet page to various persons and identifying them by name or by other means, for example, giving their telephone number or information about their working conditions and hobbies, constitutes the processing of personal data wholly or partly by automatic means. After this first point, the court confirmed also the second point for which Mrs. Lindqvist was fined. So, the reference to the state of health of an individual amounts to processing of personal sensitive data within the meaning of Article 8 of Directive 95/36. And this is referred to the fact that Mrs. Lindqvist wrote about the foot injury and working on medical grounds about one of the parishioners. For what concerned the third and last point which Mrs. Lindqvist was fined, the court in this case didn't confirm the breach of the Data Protection Directive. So, the court, in the preliminary ruling, affirmed that there is no transfer of data to a third country within the meaning of Article 25 of Directive 95/36, where an individual in a member state loads personal data onto an internet page, which is stored on an internet site on which the page can be consulted and which is hosted by a natural or legal person who is established in that state or in another member state, thereby making those data accessible to anyone who connects to the internet, including people in a third country. So in this case, for what concerns the transferring of data to third country, the court pointed out that the directive, of course, also lays down specific rules intended to allow the member state to monitor the transfer of personal data to third countries. However, we have to underline the fact that given the state of development of the internet at the time the directive was drawn up, and consider the absence of criteria applicable to use of the internet, it takes the view that the community legislature did not intend the expression transfer of data to a third country to cover the loading of data onto an internet page, even if such data are thereby made accessible to persons in third countries. Third and last part of the court ruling. Moreover, answering Mrs. Lindqvist's reasons about the exemptions from data protection laws, the court affirms that exemptions available under the directive for where data is processed for purely personal or domestic activities were ruled as not applying in this case. Why? Because those exemptions had to be read as relating only to activities which are carried out during private or family life of individuals, which is clearly not the case with the processing of personal data consisting in publication on the internet, so that those data are made accessible to an indefinite number of people. So, I would like to conclude the presentation analyzing the relevance of the case. So we can easily affirm that Bodil Lindqvist's case represents a crucial moment for the development of the data protection law enforcement, and it constitutes also the first time in which the court rules on the scope of the Data Protection Directive 95/36. And the scope, the objective of the directive, is maintaining a balance between freedom of movement of personal data and the protection of private life. This is the main aim, scope, and objective of the directive. And for the first time in Bodil Lindqvist's case, this was underlined, established, and clearly ruled. Furthermore, the court clearly points out that the provision of Directive 95 36 do not in themselves bring about a restriction which conflicts with the general principles of freedom of expression or other freedoms and rights which are applicable within the European Union. It's important to keep in mind that it is for the national authorities, as the court underlined and stressed out, it is for the national authorities and courts responsible for applying the national legislation implementing Directive 95/36 to ensure a fair balance between the rights and interests in question, including the fundamental rights protected by the community legal order. So it is every time crucial and essential for the national authorities to applying in the best way they think through an implementation the legislation of legislation and rules of the Directive 95/36. So for concluding, I wanted to share the cytography that I consulted and used to make this presentation. And I would like to thank all of you for your attention. And I hope this presentation was interesting.